Hi, everyone. Welcome back to the third session of Morrison and Foerster and Nucleate's Advanced Topics in Patent Law course. We had a great discussion last week, and we look forward to continuing these discussions over the next several weeks. Today's session will focus on medical device patent drafting and IP strategy, which will be led by my colleague, Gloria. I've had the pleasure to work with Chris on numerous matters, and he is very knowledgeable in the medical device space. So I think you all will enjoy his talk. But before we begin, I have a few housekeeping announcements. We welcome your questions during this 1 hour session. Please use the Q&A feature on your Zoom screen, and we will do our best to answer your questions as we go along and at the end of the session. And I'll help Chris by trying to interrupt him periodically to get your questions out to him. If you are getting any technical, if you have any technical difficulties, please use the Q&A feature or email Nora at moore@mofo.com. If there are topics that you are interested in hearing about but are not included on the course syllabus, please always share your ideas with us, and we'll definitely consider them in developing additional content offerings in the future. The presentation materials will be available at the end of the course on our website. And we will be circulating surveys at the end of each session and appreciate your participation and input so that we can continue enhancing these courses in the future. As a reminder, there are class office hours available. If you are interested in an initial 30-minute consultation with a MoFo attorney or patent agent, please send us an email. And I think, Nora, maybe you can make that email available instead of me reciting it here. And there's no charge for that initial consultation. And finally, our firm and group is actively recruiting patent agents, scientific analysts, and technical analysts. And we even have an internship program for college and graduate students. So if you're one of those interested patent savvy individuals in the audience, please take a look at our recruiting website. And with that, I will hand it over to Gloria, who will begin this discussion.
Thank you very much, Anita. Let me share my screen here so everybody can see the presentation, and I will jump right in. So as Anita said, I am talking today about medical device patent drafting and IP strategy. So the first part of my discussion is going to be sort of some background, some tips on medical device patent drafting. And so the goal here is to give you guys a sense of what goes into drafting a patent application on medical devices to help you in terms of reviewing patent applications that may be prepared for an invention of yours or of your company's, or analyzing other people's patents, just sort of to give you a sense of what to expect. Some of this material may be cumulative to what you've already seen before in some of the previous courses. And it's also not exclusive to medical devices. A lot of these tips can be applied to many other things as well. But I'll try and flavor it as much as I can, tailor it to medical devices. And then the second half will be on the IP strategy aspect of it, things you want to think about in terms of, what do I file on? How much do I file? When do I file? Those kinds of things. So just want to start off with here, what is a medical device? The only point of this slide is really to just hit home the fact that medical devices are involve a wide variety of technology. So it can be, purely mechanical things like orthopedic implants, up to very complex computer systems, imaging systems, robotic systems, et cetera. And so the range of technical areas that medical devices touches is very, very large. And so you'll often have different, patent drafters with different technical backgrounds working on different aspects of a given, technology space. In robotics, maybe you have, people with some computer science or AI background helping on that, and then maybe on the medical side, in terms of how the robot interfaces with the patient. I'll use let me illustrate this a little bit further. So here's a simple imaging system I took from some patent application. This is an imaging system to just kind of give you a sense of, the wide variety of technology that can go into, one area in medical devices. So in this case, this is a endoscopic imaging system. So you have an endoscope that can involve, so, what kind of technologies that involve, or what kind of inventions could be there, the optics, for example, the mechanical configuration, the interface between the camera head and the scope itself. Of course, the imaging sensor within the camera head, those are very sophisticated sensors. They have to deal with, oftentimes not ideal light situations. They have to be robust, they have to be cleanable, so that they can be repurposed after each surgery, et cetera. So there can be, inventions in all these things. And then, of course, illumination, image processing, which can involve, artificial intelligence, that kind of thing. So, the point of this is that, the patent drafting isn't going to be a one size fit all. It's not going to be like medical devices. This is exactly how you draft a patent application. It's going to vary depending on the technology, that you're working on. Is it mostly software involved? Is it, purely hardware? Is it a combination of those things? But some of the tips that I try and provide during this presentation, hopefully are applicable fairly widely. So I'll start off with the claims, the most important part of the patent, because that defines your property right. And I think you guys have some experience with claims in the previous courses, but I'll just give you a general overview. So the claims, which appear at the end of the patent, if you're curious, they, there are independent claims and there are dependent claims. So independent claims stand on their own. Dependent claims refer to a previous claim. And the structure of these
Chris?
claims.
Just
Yes,
wanted to know your slides are not advancing.
oh, they're not advancing. I apologize. There we go.
There you
Is that
Yes.
okay? Perfect. So the claims, as you can see here now, they generally, the structure of them, you have a preamble, a transitional phrase, and then the limitations. Preamble, just generally speaking, could be an apparatus, a system, or a method. Transitional phrase in medical devices is most commonly going to be comprising, which is open-ended. It means the following list of features must be in the apparatus, the system, the method, in order to infringe this claim. But an infringing device can include other things as well. So it's almost always going to be comprising in medical devices. Advance it here. Okay, so in terms of claims, how are they drafted? One of the very important things in terms of drafting claims is to know what the quote unquote prior art is. So what, was known at the time, and the time being, when you file the patent application, what was known by others, what was publicly known. And so in most cases, you as the inventors or entrepreneurs, et cetera, you'll know your field fairly well. So you may have a good handle on this. And so you want to make sure you communicate that to your patent attorney or patent agent. And the reason for that is it's going to heavily impact how they draft their claims, how broadly they draft the claims. And so, you don't want to draft claims so broad that, it's just going to cover all kinds of prior art, because then when it gets to the examination period, it can waste a lot of time. But you also don't want to draft it too narrowly so that, you're not fair the full scope of what your invention, of what you could, given your invention. So in terms of prior art, you don't want to be focused on just your particular field. You also have to think more broadly, because that's what patent examiners will do. They will look more broadly. So for example, in imaging, maybe a certain type of image processing has never been done in the medical space, but maybe it has been done in, I don't know, satellite imagery or what have you. So you may not be as familiar with that, but that is something to take into account. And a way you can tease out a lot of these things is through patentability searches. And so these are searches done by search experts, essentially, who, you give them some description of your invention, and we and also others can put together do a search based on those technical features and identify prior art. And then you can review that prior art and see, is my invention out there already? Is it already known? Or, how broadly can I claim it? So more sophisticated companies, clients often will forego the patentability search because they tend to be very knowledgeable about the field. They know their competitors, they know who files patent applications in the space. And so they have a pretty good handle on what is new and what is not. The more, newer companies maybe do need the patentability searches because maybe they've been focused in research and they don't really know the broader field, or it could be that an idea has been out there for a while, it just was never commercialized, so you just didn't know about it. So patentability searches is something that a lot of smaller startup companies definitely I would encourage you to do. It can save you money in the long run and can also strengthen your patent application. On this slide, I also wanted to give you a sense of how claims are drafted. So there's sort of, in the terms of medical device space, sort of two primary ways to do it. You can do it structurally or functionally. So a structural limitation would be, I don't know, a screw. A functional limitation would be, wherein, component A is attached to component B. So it doesn't say how it's attached, doesn't say it's attached by a screw, but it is attached in some way. So looking at the example provided here, there's a couple of functional limitations. So for example, the last limitation, a treatment arrangement in which the extravascular region of the electrode is located at extravascular location for extravascular, delivery of an electric field. So there's some structural aspects to it, but it's also, functional in the sense that it has to be positioned in order to provide an extravascular delivery of an electric field. So functional claiming is a good way to claim very, very broadly. Again, because if you define a certain structure, either at the time there could be different ways of achieving that's the same function, different structures, or maybe in the future different structures can be developed to achieve the same function. So you'll generally see the broadest claims are going to be ones that heavily rely on functional claiming. So when you review claims, you should see this, and that's why it's done that way. Slide here. Okay, so in claim drafting for medical devices, it's important to think about different levels of protection. So I mentioned
Let me ask you a
different
question. Sorry to interrupt. Before you kind of get into different levels of protection, can you speak a little bit, particularly on the medical device side, when there's a lot of figures that kind of show how the parts are connected? If the claims actually are referring to different parts referenced in the is that a common approach? Is that a way that people should start thinking about drafting the claims? Is that something that people should think about as sort of limiting how to describe their inventions?
Right, that's a good question. So it's done both ways. Sometimes if you look at the terminology in the claim, it is mapped one-to-one to what's shown in the figures. You can see, component 101 is called the, imager, and that's the exact same word used in the claims, but it's not necessary to do it that way. And sometimes you'll be hard pressed it'll take a little bit of time when you're looking at claims to figure out, okay, where in the specification is this described? It's not clear because it's not using the same terminology. Generally, I think the best practices there is two things. First of all, in the specification, you should use the exact terminology you're using in the claim, but you present it in a very broad way. So before description of the figures, there should be some general description of the invention that's presented very broadly at the beginning, and then you get into more detail, but without reference to the figures, because what the point of the figures is to provide examples of the invention, not define the invention. And what patent practitioners want to avoid is that the description and the specification being sort of incorporated into the claim interpretation, and in effect the claim being interpreted more narrowly than it otherwise would have. And so, you want to be descriptive in terms of illustrating your claim. So you provide enablement and written description support, which I'll get into in a little bit. But you also don't want to limit the interpretation of your claims too much. So hopefully that answered the question, but also get into a little bit more later on about sort of the link between the description provided in the specification and the claims. So different levels of protection. So as I mentioned, you can have apparatus, system, method claims. These can be, if you have an invention, it can be claimed in these different ways, and it usually always will be claimed in these different ways. So for example, here, let's say the invention has to do with imaging. I can have a system for imaging that has an imaging sensor, an imaging processor, and a display. That can provide protection if a system, for example, if a potential infringer is selling an entire system that has all these components. However, let's say the crux of my invention is a certain image processing algorithm, and I have a potential infringer that is only doing, part of that system. They're not doing the entire system. They're not providing a display, for example, or they're not providing the imaging sensor. Then I can still protect my invention against that type of infringer using, an apparatus claim, for example, that discusses just an imaging processor that processes, or excuse me, in this example is the imaging processor and not the imaging sensor. Then I can have a claim drafted just on that imaging processor, and so that can cover that potential infringer. And then a method claim is another way of getting at it, and it can provide some different levels of coverage relative to a system claim. So in a system claim, it can be invalid, or if there is a system, a known system that could achieve the same function. Let's say you're claiming a system that can do some kind of imaging in a certain medical context. And that makes it through the patent office and you get a patent on that. And then you try to assert it, and then in a litigation, then there's some obscure imaging system, who knows where in Russia that there's some prior art reference that describes it, and it's for, I don't know, imaging in a mining context, metal mining context. Well, if you have just a system claim, if it is true that Russian mining imaging system is capable of imaging in the medical space, as you've claimed, then your system claim is invalid. However, if you claim it via method using such a system in order to image in the medical field, then that Russian mining imager reference is no longer invalidating. There has to be then another, the limitation that is missing from that, which is using such a system in order to image, in the medical space. So you can get different levels of protection with these different types of claims. And so you should see these if, when a patent practitioner drafts a patent application, you should see these different levels of claim types. And if you don't, then, you should ask questions. And so this slide actually goes into a little bit of that. You definitely want to think about who's the potential infringer. So when you're talking about claim drafting, is who are your competitors? What are they actually providing? So maybe, you're providing several components of a system, but you could have a potential, a competitor, potential infringer who's only going to do one of those components. In fact, maybe your product makes it to market, it's hugely successful, and there's, some out there who want to, carve out some of that market, and maybe they'll start making some components of that, maybe some simpler components of your system that they can reverse engineer. Well, if you've claimed the entire system and that, potential competitor, what have you, is only doing a component, then you won't have a claim that reads just on what they're doing. And so you can't go after just them necessarily. And so you want to think about who's the potential infringer and how can I have claims that would read on just that one party instead of multiple parties. So again, using the example here, if I have a system that includes an illuminator, an imager, an image processor, a display, do you really need all those different components? Or could you have a claim just to, for example, the imager? I mentioned using method claims to cover, the use of medical devices. So there's you have to be careful in terms of surgical methods or medical methods, which are not patent eligible in many foreign jurisdictions. So they are eligible for patenting here, but in some jurisdictions such as Europe, they're not. So if they involve, a surgical step, et cetera, then you're not going to be able to get a patent on that. But you can still get a patent on the system that can be used for that method. You can also, if you have a method for that let's say your method is intended to be used, let's say surgically, just using the imager example that I've been using. If it's endoscopic imaging, you're going to insert that into the patient. That's a surgical step. So you wouldn't be able to claim that. But if really your invention is about a particular imaging algorithm, then you don't need to claim, then you leave out the step of, let's say, capturing the image within the body. As I've shown here in this example, on the left-hand side would be something that would be considered a surgical method, wouldn't be eligible in, for example, Europe. But on the right-hand side, I don't actually have that surgical step. My first limitation is receiving an image of tissue of a subject. So that's not actually requiring the capturing of the image. It's not requiring the surgical step. The argument could be made like, hey, I'm just doing research. These images were in a database somewhere, so I don't actually require a surgical step. And then you want to support that in the specification. And so if you have description of surgical methods, you also want to have some kind of description of, oh, hey, this can be used non-surgically as well. So I'll go through so those are the claims. Now I'll go through the written description aspect of the patent application, starting with the background, and just some tips on, how do you know what's a good background versus not a great background? How are these things drafted? In the background is to describe the state of the art. It does not need to be exhaustive. In the US, it's normally fairly short, just sort of tease out a little bit of, what's the space in which this invention appears. But, you typically, different practitioners do it differently, but oftentimes practitioners will avoid including specific reference to prior art. So they won't say, this prior art describes this system, this other one describes this system, that therefore there's a need for these things that are missing from these systems. You'll see that in a lot of older ones, but more and more that's being omitted because that sort of gives a map to somebody who wants to piece together an obviousness argument, honestly, for your claims. Where you can just say like, oh, well, just reading your background section, it's fairly evident what the need was. And so, with that allegedly being well known, as you've stated in the background section, then, your invention is obvious. So we tend in the US to keep the background section fairly short. In contrast, in some foreign jurisdictions, they tend to be more exhaustive in that. And the reason for that is they have a more strict requirement oftentimes in many jurisdictions to support an inventive step argument to show that, hey, this is why this invention is inventive. Which is less important in the United States, because really in the United States, what you really need to do is just show that there's some feature that's missing from the prior art and wouldn't have been obvious over the prior art. So there's this sort of tension. And so you try to thread the needle to the extent that you're going to have or expect foreign filings outside the US, and sort of draft a background that says something, but not too much. So the drawings, Nita mentioned this before. So the drawings are examples of your invention. They are not the invention, but they do need to be complete. There is actually a regulation that every feature in the claims has to be shown in the drawings. So this can sometimes, come up during prosecution where maybe you left off some feature. Maybe you're claiming, just a simple example, a spring in a certain location, and you've described it in the written description. It's there in a paragraph form. But if you haven't shown it in the drawings, then examiners can point to this regulation and say, hey, you're missing a drawing. And the problem that you run into is that you can't then add a drawing because that's considered new matter, even if you've described it again in paragraph form. So here's a typical way of showing a system, block diagrams. So again, these things don't have to be super detailed. You don't have to do CAD models, et cetera. You want to think about, how do I describe it conceptually? And whatever the best way of doing that, if it is in fact, a mechanical system, maybe an implant, then maybe you do want to go more detailed in terms of, detailed CAD-like modeling. But if it's, a software system, et cetera, then something like this is sufficient. More and more medical devices involve software, and the typical way of describing, or I should say, showing software in terms of figures is through a flowchart like this. So oftentimes this will be taken from the claim language itself, just put into a flowchart like this. This is a very simplistic way of doing it, and it can be adequate. Sometimes there's more complicated flowcharts that show, decision points and, where certain data is coming from and that kind of thing. So it really just depends on what the invention is in terms of how it's described in the drawings. So the detailed description, I mentioned a little bit of this before. So the detailed description, it is describing, again, the figures, it's describing the invention, and it sort of has two roles. So one role is to, sort of define the scope of the invention, but also to illustrate the invention with those examples in the figures. And so what I like to see, or what I do in my practice, as I was mentioning before, is I start off with a general description of the invention without reference to any of the figures. And then later on, I jump to the figures. And the reason for that is that, if you only describe what's in the figures, then there is an argument that, the scope of your claims should be limited to what you've described. So if you say, the invention is a system as shown in figure 1. Well, then arguably you're limiting yourself to the system shown in figure 1. Whereas if you disassociate the description from the figures, then you can make the argument that, hey, I didn't say that it is exactly what's in figure 1. Figure 1 is just an example of my invention. Another way of sort of supporting the scope of the broadest scope of your claims is to provide as many examples as possible. And so when you're talking to a patent practitioner and you're describing your invention, you also want to keep in mind different ways of doing the same thing. So even if it's not as elegant, or it's not as, or it would be more expensive, et cetera, you still want to explain that to the patent practitioner. They can include that in the description, and then that provides the maximum support in terms of scope of your claims. It can also help, and I'll get into this a little bit later, it can help if, like, let's say in the future, let's say when you're describing your invention, you thought it would be too expensive to do it in such and such way. So you didn't really, that's not the way you chose to do it. But maybe 5-10 years down the line, that mode becomes much less expensive, and then it actually is ideal, or a better way of doing it. If you've described that in your specification, then you can actually get claims to that later on in a continuation, using continuation practice, which I'll describe later. So I've gone into this a little bit. So sort of the legal requirements for specification drafting is that it provides written description support. So basically establishing the inventors were in possession of a claimed invention. So basically that you're not claiming what you didn't have, essentially. So the specification must reasonably convey to one skilled in the art that they were in possession of the claimed invention. And so that is, it's not a high bar. You don't have to just describe every little thing. Again, if one's skilled in the art, reading your specification can make and use the invention, that's sufficient. And Role of the specification is it provides a basis for amendments during examination. So your claims that you file with the patent office, they will most likely change during examination because the examiner will find prior art that they find anticipates or renders obvious your claims. And so, to add limitations to narrow the scope of your claims, the basis for those has to come from the specification. And as I said, multiple examples, more examples, the better. Another requirement is that the specification enables the invention, and this isn't such a high bar in the medical device space. Again, one is skill in the art. As long as they can make and use the invention without undue experimentation, then the description is sufficient. One other drafting consideration is indefiniteness. This goes more into the claims. And so this is whether those skilled in the art would understand what is claimed when the claim is read in light of the specification. So where this mostly comes into play is, relative terminology. So, high, low, big, small, that kind of thing, that kind of relative terminology can get you into trouble. So either it should not be included in a claim, or if it is, then include a definition in the specification. So for example, in this example I provide here, what's being defined is the word immediate. So immediate may be understood to be 500 milliseconds or less. So if you provide that definition in the specification, then you can use immediate in the claims. But it's usually best to just leave out that kind of relative terminology from the claims altogether. Medical device design patents. So design patents is, some people are familiar with them, a lot of people are not. These can be quite valuable tools in your overall IP portfolio. And so what design patents are is you are patenting the ornamental design applied to an article of manufacture. So I have some examples here of how that's done. It's typically done in black and white line drawings. So at the top here, the black and white line drawing on the left is the design patent, and and in this case, there is an accused product on the right. And so the design patents use two different line styles. They use solid lines and dashed lines. Dashed lines are not considered part of the claim. So only the solid lines are considered part of the claim. So in this example here, there's a knob, sort of a fluted knob sort of at the top there. So that's claimed, that's shown in solid lines. And there's, a trigger portion that's also claimed. And the rest of it is not claimed. And so what's valuable about design patents is they're really easy to get. They almost never get any prior art rejections. They're relatively cheap. If you see a design patent, it's really just the figures. That's its substance. There's no real written description of it, and they can be very valuable in terms of damages. And the reason for that is that you get damages on the article of manufacture to which the ornamental design is applied. And so contrast this with what are called utility patents, in which apportionment comes into play. So if there is a product that was sold, then in terms of damages for a normal utility patent, a determination is made in terms of what was the value of the invention in that sold product. In contrast, for design patents, the article of manufacture is what you get damages on, not just, for example, in this case, not just the trigger portion or the knob portion, but rather the entire thing. And it is a little bit uncertain. There's certain uncertainty in the law in terms of what is the article of manufacture. The famous case is Apple v. Samsung. Apple got huge damage awards on the iPhone, based on design applications to, the icons, for example. And Samsung tried to argue that, it should be the article of manufacture in that case should be just the graphical user interface, not the entire iPhone. And so anyway, so there's some back and forth on that, but you can get some very high awards with design patents. And their term is 15 years from issuance, and there are no annuities, which are fees that you have to pay during the life of a utility patent. You don't have to do that for design patents. So design patents, so it can be a very valuable tool. And one sort of area that I like to advise my clients to consider design patents are in the space of consumables. So if you have fancy product out there, and you may have some companies who want to come in and get in on your consumable market for that product. So if you have, let's say, a novel connector to your system, and consumables have to be designed in a certain way to connect that to connector, you can do a design patent on that connector. You may ask yourself, well, what's ornamental about that? But you can get a design patent on that, and so that can protect that aspect of it. You can go after, people trying to get in on that, on your consumable market. And it can be valuable also where, for example, you can't get a utility patent. Again, to go back to a connector, how novel is your connector really that novel? Would it be considered obvious? Maybe you wouldn't be able to get a utility patent on that. So that could be a space where you could still get a design patent. So something to consider. So that's my overview or tips on patent drafting. So I'll jump in a little bit to IP strategy in terms of medical devices. So in medical devices, there's usually not one blocking patent. That may be the case in pharmaceuticals, for example, but typically not in medical devices, because there's just different ways to achieve the same function. So usually, a competitor is going to be able to find a design around, even if it's more expensive. So what you need for value is a portfolio of patents. So don't think, hey, I'll just get that one or two patent and I'll be good. You want to get, a whole slew of patents, and that sort of creates a patent thicket, as they call it, that makes it very difficult, can make it very difficult for competitors to, to design around all those different patents that you have. So one consideration to do is provisional applications. I don't know if you are familiar with those, but those are not examined, and then they're converted to normal, what's called a non-provisional application within a year. And so you can use these provisional applications to get, an early filing date. Filing date is key these days in the United States because of the first to file system. And so you can get that early filing date. And within that year, maybe you make some changes to the system. Maybe you don't, but you use that time to get marketing out there, get production out there, that kind of thing. And provisionals do not affect your term. So the term, they won't eat up a year of your term, essentially, of your patent. So provisionals can be a valuable tool. But you do want to be careful with incomplete provisionals. So we see this a lot, especially with startups where, obviously you don't have a lot of capital at first to devote to, your patent portfolio, for example. And so you may throw something together and file it as a provisional just to get something on file. The problem with that is that when you do convert that to non-provisional and you get some claims drafted and you get claims that, can make it over prior art, then that provisional may not actually support that claim scope. And what that means is that you essentially, the year before you file that non-provisional application, it doesn't, you don't get the benefit of that year. So if the provisional doesn't support your claim scope, then you can't claim priority all the way back to that provisional. It may not provide support for, narrowing limitations that you may need to make during examination. And then also something that we've seen is, an incomplete provisional is filed, or even an incomplete non-provisional, because, for, financial reasons or what have you, and you end up not being able to get a patent on that, or you get a very narrow patent on that. Well, that has now because it publishes, become prior art to later applications that you do. And so you can oftentimes shoot yourself in the foot by filing these sort of incomplete applications that don't provide good claim support and all these things that I've been talking about. So you want to be careful about that. And it's also often advertised as like, hey, we can get your provisional on file very cheaply and quickly, that kind of thing. But there are risks to doing that kind of thing. So the motivations to patents, freedom to operate, in no particular order here, freedom to operate. So you want to think about, you want to create space to innovate. So you want to, whatever technology you're practicing, you want to be able to continue to practice that technology. And if you create patents in that space, then that helps you do that. So keep in mind that competitors can prevent you from innovating in your own space by patenting in your space. And so if you can patent in your own space, then that can prevent them from doing that. You can also exclude others from practicing your technology. This is sort of the classical, obvious reason for patents. Prevent others from entering the market or expanding their market share, et cetera, or, making it more expensive for them to do so. Maybe they don't have the key feature that you have and they're less attractive in the marketplace. But sort of the flip side of the freedom to operate is you can also exclude others from practicing their technology. So, if you're patenting in their space, let's say they would have arrived at the same invention on their own, but your patent is out there, then they can't do that. You can stop them from practicing their own technology. That can be a competitive advantage. And then finally, serve as a shield to deter competitor infringement suits. So this is more important for larger companies. So if they have a robust patent portfolio, then their competitors are not going to be as excited about suing them. Because they'll likely be hit with counterclaims on these other patents. And so, sort of a mutually assured destruction concept here. So that's another reason to develop a robust patent portfolio. But again, that's typically for more mature companies. One other that I didn't mention here, but is to provide some value to your company. So if you don't have patents to protect your technology and you have an investor come along and looks at what you're doing and says, oh, this technology is great, but what's to stop somebody else? I buy this, I invest a lot of money in this or what have you. What's to stop somebody else from stealing the idea, taking it, and then, then my investment is worth less. And so having a robust patent portfolio, patent applications on file that are quality, because they will, a potential investor will have their own patent attorneys review those and say, like, what's the value of these? And so it's good to have quality patent applications on file. Oftentimes you won't have patents yet, depending on how mature your company is. But that's also a big motivation for startups to patent protect their IP. So what should you patent? I mean, you can patent anything: a device, a component, system, process, a method of making, a method of using. Software is patentable. So, any of these things. Typically in the medical device space, what you're patenting is an improvement over something that's known. So again, usually not going to be, a patent on, some seminal technology that is going to dominate the space. That's usually not the case in medical devices. It's usually going to be an improvement. And so in terms of improvements, you want to think about, from what was known at the time, what did you develop based on what was known? What problems did you solve? Usually in those solutions, there's an invention there. So that's kind of how you can think about what is worth patenting. And then, of course, if you have a product, making it to market, you want to be able to protect that as much as you can. So obviously, you should patent as much of that as you can, but then also what could possibly be in the product in the future. So what do you see coming down the pipeline, in terms of how the product may change over time, given further investment in it, et cetera. And then also what could be done that solves the same problem in a different way. So this is to try and protect design arounds, for example. So if a competitor sees a patent on exactly what you're doing, they can design around it to avoid the patent. But if you've also captured different ways of doing the same thing, then the value of the patent will be even greater. So when to file for a patent, I sort of mentioned this earlier, but first to file gets the patent. It's a race to the patent office. So this was a relatively recent change in the United States. It used to be first to invent is the one who got the patent, but now it's the first to file at the patent office. And so this harmonizes with the rest of the world, which I think is also, at least vast majority are also the first to file gets the patent. So there is this pressure to give it on file quickly. You certainly want to file before a public disclosure. In many foreign jurisdictions, a public disclosure is an absolute bar to getting a patent. So if you give a seminar presentation on day one and you file your patent application on day two, then that presentation, to the extent it was available to the public on day one, is going to be invalidating for that patent in many foreign jurisdictions. The US offers a grace period of 1 year for your own public disclosure. So you could do a presentation on day one, and then 364 days later or 365, you need to have filed that patent application. We generally, most of our clients, would consider filing foreign. So we always advise filing before public disclosure and not using that 1 year grace period. Another consideration is to file for a patent before you enter a collaboration agreement. So, maybe you've developed some technology and you need somebody to manufacture it for you. Ideally, before you start entering into talks with that company where you're sharing technical details, you'd like to get a patent application on file. And the reason for that is that it makes clear what was yours versus what came out of the collaboration. So even if you have an agreement, saying, hey, with whoever you're collaborating with, saying, hey, what is mine and what's yours is yours, it could still be arguable, what details or what aspects of the invention did in fact come out of the collaboration. And that's something that's going to be, litigated years down the line. And, you may not have great documentation, or people may not remember anymore. But if you get a patent application on file before that collaboration, it's quite clear that everything in that patent application was absolutely yours and was not contributed by the collaborator. And it's important here to realize that things like non-disclosure agreements do not protect you from a collaborator filing on your patent application. So you may have contractual remedies, but in terms of being able to get a patent, if you have a competitor that files on it first, then you can be out of luck. The last consideration is before an offer for sale. This is I don't think exclusive to the US, but there's not as many foreign jurisdictions have this bar, which is if you put your invention on sale, then that starts the clock ticking. You do have a 1 year grace period for filing a patent application. And again, here also non-disclosure agreements do not help. It does not have to be, at least as of now, does not have to be a public sale. It can be a private sale and still trigger this bar. So I mentioned this earlier, continuation practice. So to the extent you don't know what continuations are, you file a patent application, first patent application. During the pendency of that patent application, so before it issues as a patent, you can file another patent application, and that claims priority to that first application and is treated as if it was filed on that same initial filing date of that first application, or if it claims priority back to a provisional and back to the provisional filing date. And you can file as many of these as you want, as long as you keep the chain of pendency going. And so these are used, for example, there may be a patent application that describes a lot of different inventions. Just going back to the imaging system I was describing before, maybe in a patent application, it describes, the imager and then also the illumination system. And maybe you have a set of claims initially that you filed in the first application. Those claims are just about the imaging, the imager itself, and not the illuminator. Well, you could file a continuation with claims, different claims, but the exact same specification and drawings, different claims that are directed to the illumination system. So you can do that to the extent you have additional subject matter that is not covered by a previous claim set. You can keep filing continuations to get claims on that different subject matter. You can also, attempt to get different claims on the same subject matter. So let's say in your first application, you really just wanted to get a patent. And so, you told your patent attorney, hey, just whatever the examiner wants to do in terms of amending the claims, narrowing the scope of those claims to get us an allowance, to get us a patent, let's do it. So you do that, you get your patent, but then you're like, well, I don't really think, in view of the prior art that the examiner uncovered, I think we really deserve broader coverage than what we got. Well, you can file a patent, a continuation during the pendency of that first one with broader claims, and basically you get another bite at the apple. You get to try again. And so this can be very valuable to build up. I mentioned earlier the importance of building up a patent portfolio. This can be very useful for building up a patent portfolio relatively inexpensively, because you're not having to recreate the specification and the drawings. That's done once, and then all that's new for each application is the claim set. And you can also do this to do what's called targeting. So targeting claims. If you see a competitor that came out, let's say you had a patent out there, the competitor saw that patent, they did a design around. And you think that their design around is actually within the scope of what you've described in the patent application, though it may not be within the scope of the claims that you've gotten granted or that you have on file at the time. Well, you can draft new claims that that are broad enough to encompass what the competitor is doing, and you can actually get a patent. Several years down the line from when you filed it, you could get a patent on what a competitor is doing several years later. So that can be very, very useful. And so my point of telling you this is continuation practice, again, is a good way to get a portfolio of patents with a lot of different coverage. And it's also important to think about keeping a family alive. So when you hear that your patent is granted, think about, well, do I want to file a continuation? Because if you let that patent issue without filing a continuation, then you can't later down the line. That'll be foreclosed at that point. So that's all I have for you. If anybody has any questions, feel free to ask them. Anita can let me know.
Chris, we have one question here. It's about trade secrets. Can you speak a little bit about how trade secrets should be factored into an IP strategy in the medical device space?
Yes, that's a great question. Actually, something I should probably add to this presentation in the future. So trade secrets, we get a lot of questions about that. Trade secrets are only valuable if, in fact, you can keep whatever it is secret. So if, whatever the invention is going to make it into a product that it is going to make it out into the field and can be reverse engineered, then trade secrets aren't going to do you any good at all. And so trade secrets are often used. So for example, in software space, they may be used in like a server system that runs in the background that, a consumer or somebody in the public is never going to be able to know what's going on back there. They just see the results. Then trade secrets might be useful for that. But, one thing I will caution about trade secrets is that, other companies, other parties can independently invent. So let's say you decide to pursue trade secrets and not file a patent application on a particular invention. Well, if another party goes out there and invents the same thing and files a patent application on it, guess what? You're out of luck. You can't practice that anymore, because it is not an excuse to say that, hey, I was already practicing this before you did it. That doesn't matter. If they get a patent on it, they can stop you from doing it. So it's a big risk I would say, in a field where, let's say, you have competitors that patent aggressively. It's a risk to keep something as a trade secret rather than file a patent on it. But again, if you think it's something that, again, is going to be in the background, won't be able to be reverse engineered, competitors may be unlikely to file on a similar thing, then trade secrets may be valuable in order to sort of maintain that competitive advantage. Because of course, when you file a patent application, you are telling everybody what you're doing, and so they can take that and use it and improve on it.
Thanks. I think with that, I don't think we have any other questions for our time together. So thank you very much, Chris.
Great. Thanks, Anita. Thanks, everybody, for your time today. I appreciate it.